Thank you, Mr. Chairman. Now, historically, if an employer violated the legal rights of its workers through, say, an illegal firing, the employer was on the hook for damages. Today, though, some big companies have figured out they can hide behind a complex arrangement like subcontracts and franchises to dodge their legal responsibilities toward their workers. Here's how it works. The big parent company may functionally control every tiny detail of what the workers do, including how much they get paid, how they're trained, and when they get bathroom breaks. But when, for example, an employee doesn't get paid legally required overtime, the big company steps back and dumps all the responsibility and the costs on the franchise owner, even if the franchise owner was just doing what the big company forced him to do. So for decades, going back to the 1960s and affirmed by both the Supreme Court and the NLRB, the law has been clear that there is some sort of joint employer test to determine when, for example, a parent company is really in charge of franchise employees. No one disputes that such an obligation exists. Instead, this dispute today is really about how much control is enough to hold a parent company responsible for what happens to employees in its franchises. Is that right, Mr. Babson?
I think not.
You don't think this is a fact question that we're disputing here and that the underlying law has been clear for decades?
With respect, Senator, I think your premise is misplaced. I do not. I've been representing, with the exception of my service at the NLRB, for most of my career, I've been representing employers in these matters. And I will tell you, during my service at the NLRB, I found that in the overwhelming majority of cases, both employers and unions were trying to do the right thing.
I'm sorry, that was not my question, Mr. Babson. My question was...
Well, your premise was that, pardon me, Senator, I apologize. I'm sorry.
My question was, are we all clear on the law, and that is that there is an obligation when the employer has sufficient control, when the franchisor has sufficient control, then we have employees to whom they will be responsible and can be held legally responsible. And the dispute we're having today is solely over the question of what the facts are that trigger that.
That's correct.
Thank you.
And one of the things that troubled me about what Mr. Segunda said earlier about McDonald's, I don't know how he can say so blithely in response to Senator Franken that McDonald's is responsible. I don't know what I don't know what the facts are, and I don't think he does either.
I just wanted to establish what I thought was a pretty straightforward rule of law that I think everyone agrees with, and I'm glad to hear that you agree. But then let's look at the facts. You raised the question of the facts. McDonald's requires franchise owners to install software on their computers that collects data on a daily basis on when each employee, each and every one of them, clocks in, when each employee clocks out, and how long it takes each employee to fill a customer's order. Domino's Pizza literally tracks the delivery times of each and every employee and decides which ones, employee by employee, meet Domino's tests. So, Mr. Babson, in your view, is it clear that none of this is enough to raise even a factual question about whether the company is in control, and that the NLRB can't even ask that question based on those facts?
Of course not. I've been practicing law too long, Senator, to tell you that there's not a question. That's why the complaint is issued. It's my understanding that the General Counsel not only has been arguing for a new test of this unexercised potential, but it is my understanding, and I believe the record will show that the General Counsel is arguing even under the present test that McDonald's satisfies the employer.
Thank you, Mr. Babson. The question I'm simply trying to drive at is whether or not there are enough facts here that the NLRB should be called on to rule about whether or not there is joint responsibility. Mr. Segunda, how do you see that?
Senator Warren, clearly there's enough here under the existing tests, common law test, to look at that fact question And unlike Mr. Babson, and of course with all due respect, this is not outside the statutory authority in any way of the NLRB.
Okay, and let me just ask, I think you raised this point earlier, is the current NLRB test consistent with how joint employment relationships are determined under other major labor and employment statutes?
The current test is not. The one that was developed in 2002 under the Airborne case requires direct and immediate control. There is no such language in any other labor and employment statute when talking about common law control over employees.
So it is the NLRB that has been unduly restrictive in this area. Thank you very much, Mr. Chairman. I appreciate it, and I appreciate the extra.
Thank you.